Drenard Trust here. So a revocable living trust is a powerful estate planning tool, but it's only effective if set up and managed correctly. So here are 11 common mistakes to avoid. There's failing to fund the trust. So probate avoidance is lost. One of the main reasons people set up revocable living trust is to avoid probate, which is a public, time-consuming, and often costly court process required to transfer assets after death. If the trust is not funded, meaning assets are not retitled or transferred into the trust, those assets remain in the individual's name and must go probate, defeating the key advantage. The trust has no control over unfunded assets. The terms of the revocable living trust only apply to assets actually titled in the trust's name. So if assets are not moved into the trust is essentially just a legal document with no power over those assets. This can result in some or all of your property being excluded from the trust's management and distribution provisions. There are delays and increased costs, so unfunded assets must be probated, which delays distribution to beneficiaries and incurs additional court, legal, and administrative fees. These costs reduce the value of the estate passed to heirs. A revocable living trust is also designed to allow for seamless management of assets if the grantor becomes incapacitated. So if the trust is not funded, the successor trustee cannot manage those assets, potentially requiring a court-supervised conservatorship and guardianship, precisely what the trust was meant to avoid. So if assets are not properly transferred into the trust, the distribution may not align with the grantor's wishes as outlined in the trust document. This can lead to disputes among heirs, challenges to the estate, and prolonged legal battles. There are potential tax consequences too. So failure to fund the trust may also compromise tax planning strategies, possibly resulting in higher taxes for the estate or beneficiaries. Now, here's the second mistake. That was number one. Not funding the trust after life changes. So life changes affect your wishes and beneficiaries, like major, life events such as marriage, divorce, the birth or adoption of a child, the death of a beneficiary, or changes in relationships can dramatically alter your intentions for how your assets should be distributed. So if your trust is not updated to reflect these events, your assets may not go to the intended people or could be distributed in ways you no longer desire. So if a named trustee or beneficiary passes away or becomes unable to serve, and you have not updated your trust, there may not be any clear successor, leading to confusion or court intervention. For example, if you originally named 2 children as successor trustees, but later had a third child and did not update the trust, that third child could be unintentionally excluded from important roles or inheritances, right? Be mindful of legal and financial changes as well. So changes in state or federal laws or in your own financial situation may require updates to your trust to ensure it remains effective and compliant. So failing to update could result in unnecessary taxes, legal challenges, or assets being subject to probate, defeating the purpose of the trust. Increased risk of disputes and litigation. Basically, outdated trust can create ambiguity and conflict among heirs, potentially leading to costly and time-consuming legal disputes. Conflicts can arise if the trust's provisions are no longer matched to your current family structure or asset holdings. Number 3, the third mistake is improperly drafted documents. So improperly drafted documents are a critical mistake when creating a revocable living trust, because the trust document serves as the legal foundation for how your assets will be managed and distributed. So if the document is unclear, incomplete, or contains errors, several serious issues can arise. There are legal challenges and confusion that play a part in this. Poorly drafted trust documents can lead to confusion amongst, beneficiaries and trustees, increasing the risk of legal disputes and challenges to the trust's validity. Ambiguities or missing details may result in unintended distributions, among the heirs, or even court involvement to interpret or correct the document. So Unintended distribution of assets is a key factor as well in this, right? So if the trust document lacks essential clauses or contains mistakes, assets may not be distributed according to your wishes. For example, omitting a residual clause can leave out assets acquired after the trust's creation, potentially sending them through probate. There's a risk of invalid trust in that regard. So significant drafting errors such as incorrect identification of trustees or beneficiaries, missing required legal language, or failure to comply with state laws can render the trust partially or wholly invalid. In such cases, your estate plan may fail and your assets could be subject to probate, defeating the purpose of the trust. Errors in the trust document can make it difficult for the trustee to carry out their duties, potentially leading to delays, additional costs, or the need for court intervention to clarify or reform the trust. Keep in mind DIY and generic templates. So attempting to draft a trust without professional guidance or relying on generic online templates often leads to omissions or state law non-compliance, greatly increasing the risk of these problems. Risk number 4 is not naming a successor trustee. Or no backup. So why a successor trustee is essential, like there's the continuity of trust management. So the successor trustee steps in to manage your trust if you become incapacitated or after your death, ensuring your financial affairs and asset distribution continue seamlessly without court intervention. Basically avoiding legal complications and delays as well, right? Without a clearly designated successor trustee, the trust may face legal complications and unnecessary delays. In such cases, the court may have to appoint someone, which can be time-consuming, costly, and may not reflect your wishes. And then there's the probate avoidance. So one of the main benefits of a revocable living trust is to avoid probate. If no successor trustee is named, assets may be tied up in probate anyway, defeating a primary purpose of the trust. The importance of naming a backup is as goes. There's unexpected events. So people are living longer, and it's possible that your chosen successor trustee could die or become incapacitated before you. So if there's no backup, the court will need to intervene to appoint a replacement, which can create delays and additional expenses. So ensuring your wishes are followed as well. A backup, basically ensures that even if your first choice, cannot serve, someone you trust will still carry out your instructions and manage your assets according to your wishes. Mistake number 5 is overlooking tax implications. So no immediate tax benefits. So a revocable living trust, do not provide tax benefits during your lifetime. All income generated by the trust's assets is taxed directly to you, the grantor, as if you own the assets outright. The IRS treats the trust as a grantor trust, meaning it is invisible for income tax purposes, and all income, deductions, and credits are reported on your personal tax return. There is a misconception about tax savings. Some people mistakenly believe that placing assets in a revocable living trust will reduce their income taxes or shield assets from taxes. So this is not the case, and overlooking this fact can lead to disappointment or poor planning. There's post-death tax consequences. So tax status changes after death. When the grantor dies, the revocable living trust becomes irrevocable. At this point, the trust must obtain its own tax identification number and may be subject to different, often higher tax rates on undistributed income. There's the potential for higher trust tax rates. So trust can be taxed at higher rates on income retained within the trust, which can be a surprise to beneficiaries if not planned for in advance. So there's an impact on beneficiaries, right? Unnecessary taxes for beneficiaries, like failing to plan for the trust post-death tax treatment, can result in unnecessary taxes for your heirs, especially if the trust retains income or if assets are not distributed in a tax efficient manner. Now, the key takeaways you want to take away from this is a revocable living trust is primarily an estate planning tool for probate avoidance and incapacity management, not for tax reduction during your life. Ignoring tax implications can lead to mistaken expectations, missed tax planning opportunities, and higher taxes for your estate or beneficiaries after your death. So consulting with an estate planning attorney or tax advisor is essential to ensure your trust is structured in a tax efficient manner and to avoid costly mistakes. Number 6 is not coordinating with other estate planning documents, so incomplete asset coverage. So a revocable living trust not, only controls assets that are properly titled in its name. So if other assets such as bank accounts, real estate, or investments are not retitled or coordinated with the trust, they may not be covered by its terms. This can result in those assets going through probate, defeating one of the main purposes of the trust. There are gaps in legal authority, so other essential documents such as pour-over will, durable power of attorney, and healthcare directives serve critical roles. For example, a pour-over will ensure any assets unintentionally left out of the trust are transferred into it upon death. So powers of attorney and healthcare directives allow for management of finances and medical decisions if you become incapacitated, areas that are not addressed by the trust alone. So there are conflicting instructions as well. So if your will, trust, and beneficiary designations on accounts like retirement plans or life insurance are not aligned, it can create confusion, disputes, or even litigation among heirs. For example, if a will and trust give conflicting instructions about the same asset, it can delay distribution and increase costs. There's also missed opportunity for protection and flexibility. Basically, coordinating all documents ensures your wishes are consistently carried out, assets are protected, and your loved ones avoid unnecessary legal hurdles. Proper coordination also allows you to address issues such as guardianship for minor children, special needs planning, or business succession, matters that a trust alone may not fully resolve. 7 is keeping the plan a secret. So confusion and delays is why. So if your family or your successor trustee does not know about the trust or can't locate the trust documents, they may not know how to access or manage the assets after your death or incapacity, right? This can lead to unnecessary delays in distributing your asset or your estate, and may even force your assets through probate, the very process the trust was designed to avoid. So here's the mistaken actions, right? If your executor or trustee is unaware of updates or changes, to your estate plan, they might begin distributing assets according to an outdated will or trust. Discovering new documents later can result in legal disputes, additional paperwork, and increased legal fees to correct the distributions. There's a lack of preparedness, so successor trustees and key decision makers need to know their roles and responsibilities in advance. So if they are kept in the dark, they may not, be prepared to act when needed. So that basically can further complicate the administration of your estate. There are family disputes, like surprises or lack of transparency can lead to misunderstandings or conflicts among beneficiaries, especially if expectations are not managed while you are still alive and able to explain your choices. Mistake 8 is overcomplicating or oversimplifying the distribution plan. So overcomplicating the distribution plan, like creating an overly complex distribution plan, can make the trust difficult to administer. If the instructions for the distributing assets are too detailed, convoluted, or require numerous contingencies, it can confuse trustees and beneficiaries, increase administrative costs, and potentially lead to disputes or legal challenges. So complex plans may require ongoing oversight, staggering distributions with detailed conditions, or involve multiple beneficiaries with different rules. This can burden the trustee and delay the process, sometimes defeating the purpose of having a trust streamline and simplify asset transfer. Oversimplifying the distribution plan, on the other hand, making the distribution plan too simple, such as giving all assets outright to a young or financially inexperienced beneficiary, can expose those assets to risks such as poor money management, creditors, or even loss due to divorce or lawsuit. Oversimplification often fails to consider the unique needs, maturity, or circumstances of beneficiaries, which could result in unintended negative consequences for their financial well-being. So the importance of balance. So the key is to balance flexibility with protection. A well-crafted distribution plan considers the beneficiary's needs, maturity, and circumstances while providing clear, manageable instructions for the trustee. As an example, staggered distributions at certain ages or life milestones, or including asset protection provisions, can help ensure assets are used wisely and protected without making the plan so complex that it is basically unworkable. Mistake 9 is overlooking personal property. So many people forget to include personal property, jewelry, art, heirlooms in their trust, which can lead to disputes among heirs. Number 10, leaving out residual clause. Consequences of omitting a residual clause is like the unintended probate. Without a residual clause, any assets not explicitly mentioned in the trust may have to go through probate, the court-supervised process for distributing assets. This defeats one of the main purposes of creating a revocable living trust, which is to avoid probate. Assets distributed by state law, so assets not covered by the trust, could be distributed according to state intestacy laws. So this means your property might end up in hands of unintended beneficiaries, or in rare cases, even revert to the state. Family conflict and delays are part of it too. The lack of clear instructions for leftover assets can lead to confusion, disputes among heirs, and increased legal costs, as family members may need to go to court to resolve who should receive the remaining property. Missed charitable or special gifts. So if you intended for any remaining assets to go to a charity or a specific person, omitting a residual clause means those wishes may not be honored. Here are some example scenarios. So if a beneficiary named in your trust dies before you and there is no alternate beneficiary, their share may become part of the trust's residue. Without a residual clause, there are no instructions for what happens to these assets. If you require new assets after creating your trust and forget to update it, those assets may not be covered unless there is a residual clause. Mistake number 11 is not hiring a qualified estate planning attorney. So attempting to create a trust without professional guidance can lead to costly errors. And basically, an inexperienced attorney ensures your trust is legally sound and tailored to your needs. By avoiding these mistakes, you can ensure your revocable living trust fulfills its purpose, protecting your assets, avoiding probate, and providing for your loved ones according to your wishes. Now, let's talk a little bit about how you can make a living trust without a lawyer. You can create a living trust on your own in 2025 by following a structured process and using reputable online resources. So this approach is suitable for individuals with straightforward estates and basic asset distribution needs. Here are the key steps. Define your goals and gather information. Clarify why you want a trust, like avoid probate, control asset distribution, protect privacy, for example. List all assets you wish to include, like real estate, bank accounts, investments, personal property, etc., and gather ownership documents. Then you're going to want to choose the type of trust. Most individuals opt for a revocable living trust, which allows you to change or revoke the trust during your lifetime. Basically, irrevocable trusts and special needs trusts are more complex and may require legal guidance. Select trustees and beneficiaries. So name yourself as the grantor, the creator, and initial trustee so you can retain control over the assets. Appoint a successor trustee to manage the trust if you become incapacitated or pass away. List beneficiaries, who will receive the trust assets, and specify how, and when the distributions should occur. Draft your trust document. So use reputable online templates or services such as Low Depot, Freewill, Legal Templates, or eForms to create your trust document. The document should include things like grantor information, trustee and successor trustee names, list of assets and property, beneficiary details, instructions for asset distribution, trustee powers, and compensation, if any. Then sign and notarize the trust. Execute the trust document by signing it, typically in front of a notary, public. Some states may require witnesses as well, so check your state's requirements. Notarization is crucial for the document's validity and in most jurisdictions. Then you're going to want to fund the trust. So transfer ownership of assets into the trust, retitle real estate deeds, bank accounts, and investment accounts in the trust's name. Assign personal property and update beneficiary designations where appropriate, right? If you skip this step, the trust will not control those assets and they may still go through probate. Create supporting documents to, consider drafting a pour-over will to catch assets not transferred into the trust, a durable power of attorney, and healthcare directives, right? So that's what I have today. Please take a moment right now to hit that subscribe button and the like button. Once again, please take a moment right now to hit that subscribe button and the like button. I appreciate your viewership. Stay safe and see you on the next video.